Welcome to another episode of Spotlight on Scholarship. Today we're speaking with Professor Maria Kolar. She is a professor of law for our Oklahoma City School of Law. Thank you for joining us today.
I'm thrilled to be here.
Well, we're talking a little bit about your scholarship, and I'm told that it is about felony murder.
It is. Yes.
So could you tell us a little bit about the case that started your scholarship in felony murder?
Okay. The case that got me started on this particular article was a case really local, right? It came out of a southwest Oklahoma city at a place called Okie Gas Express. Two teenage boys, Stavion Rodriguez, who was 15, and his friend Wyatt Cheatham, who was 16, basically committed an armed robbery at the store. They took, there's only the owner and was the clerk that night, and they took some cigarettes and some cash and left, and that was that. A while later, Stavion came back, not entirely clear why, maybe he left something. This time the owner got himself out of the little convenience store there, went out the drive-through window, climbed out the drive-through window, locked down the building. So Stavion was stuck in the building, Stavion Rodriguez, and then called police. At that point, a lot of police, local Oklahoma City police, descended upon the building. Anywhere from, they think, 18 to 30 officers were there, and shouting various commands for him to come out, come out, arms up, all that. Well, he couldn't because the building was locked down. The little store was locked down. Eventually, he climbed out through the drive-through window, as had the owner. His hands were clear, as the later video release showed. And once he came out, there's about 8 seconds of video. He came out, showed that his hands had nothing in his hands, gingerly kind of raised his shirt, which revealed that he did have a gun in his left waistband. He then, with his right hand up and his left hand at his waistband, took the gun out of his waistband between his thumb and forefinger and dropped the gun on the ground, put his hands back up. He was pretty fortunate to still be alive at that point. And just in terms of going for the gun, as they're yelling, drop it, get on the ground, all kinds of commands. He then goes down, sort of puts both hands down, possibly to his pants are sagging, not entirely clear, but as his hands start to go toward his waistband, just a cascade of bullets. And he's hit. Later they find out that really 6 officers fired. The first was a non-lethal beanbag shot, but it was, it followed, often they call it sympathetic fire. 5 other officers shot with lethal rounds. He was hit 13 times and died at the scene. So it, a terrible tragedy. They initially said that he was an adult, but he was a 15-year-old. The part of the case that I got interested in was they initially charged his non-present co-robber, Wyatt Cheatham, with first-degree felony murder, in addition to charging him with armed robbery. The armed robbery was pretty obvious. The theory under Oklahoma law was basically that Wyatt Cheatham, although not even around at the time of the killing, participated in a felony from which a killing resulted, and even though the killing was clearly by police, that would still make him what we call a felony murder under Oklahoma law, for which the lowest punishment is actually life in prison. So it's just like any other first-degree murder. The mother of the victim, Stavion Rodriguez, pushed a lot. Her name is Cameo Holland, for the release of the videos. Because even that night, a media person happened to be across the street and saw that he had actually dropped his gun and that he had disarmed himself, even though initial reports were that he was holding a weapon and not responding. So they eventually filed a lawsuit to get the videos and all that. Eventually, in the March of 2021, about 5 months later, the video came out. The district attorney's office, David Prater, released the videos and also charged the 5 officers who fired lethal rounds with first-degree manslaughter, which is called an unnecessary killing, basically an unnecessary killing in response to a felony. So the interesting question to me was, as it came out, well, could they still convict Wyatt Cheatham of first-degree felony murder if the killing was also a criminal homicide? I mean, could you really pin the killing by officers, now charged as a homicide, upon a person simply on the theory that he was involved in starting it, basically? So that was what got me interested.
Can you clarify for us the Oklahoma definition of felony murder and tell us a little bit more about that?
Murder comes traditionally in America. We really inherited common law ideas from England. And really the difference between an unlawful killing that was a murder versus an unlawful killing that was manslaughter was whether the killing was committed with malice aforethought. So malice aforethought is one of these strange terms because it turns out over time it neither requires malice, like evil in your heart, or very much aforethought, like much planning. Traditionally, under common law, the paradigm case of malice aforethought is that you killed and you intended to kill. You wanted the person to die. That's sort of what we call express malice. You wanted the person to die. There were three other types of killings, though, that were considered also murder, malice aforethought murder. One is where you had not the intent to kill, but the intent to inflict great bodily harm. So the idea was, even if you didn't intend to kill, if you intended to inflict great bodily harm and someone died, we will call that malice aforethought murder. So that was the second. And then the third is what we often call reckless murder, or what the common law called depraved heart. When you killed by acting in a way of you didn't care at all. You shot into a crowd, or you dropped a concrete block off of a bridge over a highway. Something where, again, less than intending to kill, but what I tell my students, like, don't give a damn. Acting in an incredibly reckless way and a death results. So those were the three. And then the fourth traditional category of malice aforethought killing is felony murder. And here the theory is that regardless of what we call mens rea, or what your intent is about the killing, you committed a felony and a killing resulted, a death resulted. And so even if you didn't intend to kill or intend to harm or even were reckless, if a death results from you committing a felony, we call that felony murder. And so that's sort of the fourth of the traditional malice aforethought.
Tell us a little bit about how felony murder is different in Oklahoma compared to other states.
Good. Okay. Well, in my article, I first kind of divided the 50 states to look at who has a traditional approach to felony murder at all. And the traditional approach to felony murder says it doesn't matter what your mens rea or what was in your head and your heart. If you committed a felony and a death resulted, we're calling it felony murder. That's the most traditional and frankly most harsh version. 41 of the 50 states still have some kind of a traditional felony murder. And then the other thing, which comes out of that Stavian Rodriguez case that I broke down the states of that have traditional felony murder, is whether you allow a felony murder conviction when the actual killing is by a non-participant in the felony. Traditionally you are held responsible for the actions of your co-defendants or your co-robber. So if they shoot somebody, you can also get charged with murder, that kind of thing. Traditionally, felony murder, again, you were only accountable for the killings of your co-participants, people who were on the felony team. Over time, some jurisdictions, including Oklahoma, evolved to an approach that's called a proximate cause approach, where even if the killing was actually by what I call the other team, by the victim, by a bystander, or by a police officer, all of which would be responding in some way. So basically, of the 41 U.S. states that have felony murder, overwhelmingly, 29 of them take what we call an agency approach, where you can only be held accountable for crimes committed by your agent, your team, participants in the original felony. 12 states, of which Oklahoma is one, have this much broader proximate cause approach on the theory that you committed a felony that proximately caused a death, even though the actual killer was what I call a non-participant. It was a police officer, a bystander, or a victim. So I got interested in the 12 states that take this sort of surprising approach that you can be tagged with murder for killings by what I call the other team, your adversary in some way. I guess I wanted to see right away sort of where Oklahoma fits in the scheme, like where are we and how are other states approaching it. So I had a research assistant, Anna Reynolds, who I asked her basically to look at the murder statutes of every state and pull them for me and lay them out And so, which is a little harder than you would think, actually. So basically, then I could go through and look at them and look at the language and also look at how they were interpreted. And so I could categorize them. So that's really where it started. And she and I went back a lot, back and forth a lot, I should say, in terms of getting that complete set of statutes. Really the inspiration for this project was my intuition that even in felony murder, which is a field of law that is an area of criminal law is really criticized by scholars and judges because it often invites great injustice because you can be, again, find yourself convicted of murder even though there was really no expectation at all that the crime you were committing would result in a death. Even in this field, even in a state that allows felony murder for killings committed by police officers and bystanders and victims, even in that broader context, surely if the killing by the other team is itself a crime, there should be some sort of justice, fairness, rationality limitation on what I call pinning or putting that killing onto the original person, simply on the theory that you started it, which is a lot of the cases. The phrasing tends to be set in motion a series of events. The idea that no matter what your involvement was, if someone ends up dead, even if, again, the actual killing was itself a crime by the other side, that can be put onto you without limitation. I find that jarring, and my students find it jarring. Felony murder is of the classes in a semester. Felony murder is the doctrine that students find the most surprising. And this type of case they find even more surprising because it really jars with our idea of fairness and justice and just proportionality.
Tell us a little bit about when your scholarship and your article is going to be published and where is it going to be published?
Okay. It is supposed to come out this month, May, and it will be published by Northwestern, by the Pritzker School of Law. It is their Journal of Criminal Law and Criminology. So it'll come out this month, and they do, mostly it's criminal law scholars, and yeah.
Is there a particular main misconception that maybe the public might have about law and about its publications?
I think, for one, I don't know how much the public thinks about the kind of research we do and scholarship we do. I think when people think about research in academic disciplines, they think about science and they think about medicine, and I think it's not hard to see how that relates to regular life, that, that discoveries in science and medicine and fields like that have real impact. I think oftentimes legal scholarship is seen as sort of being removed from regular life, and sort of it's just law professors talking to law professors.
And lastly, what is your favorite part of teaching in the OCU classroom?
I love seeing students get intrigued about what they're learning and seeing, it's seeing the excitement, seeing the sense of accomplishment when you come to understand something that is difficult. Oh, and here's an interesting thing. This case here, Wyatt Cheatham, in the end, the 16-year-old, he pled guilty to armed robbery, and so they dropped the felony murder. Mm-hmm. But, my research, I'm convinced that in Oklahoma, they could have convicted him of first-degree felony murder. I don't have much doubt that Oklahoma allows that to happen, that he could have found himself convicted of the murder of his friend, which, again, is pretty implausible and pretty surprising to the public.
Well, I thank you for your time today.
Thank you.
Join us next year for our next episode of Spotlight on Scholarship. Have a great summer.